I often meet employees here in relation to employment law, and they have what they claim to be protected disclosures in the workplace. In other words, they claim to have made a protected disclosure, or they claim to have been fired for having made a protected disclosure, or they claim that they have been penalised in the workplace because they made a protected disclosure. The Protected Disclosures Act 2014 brought into Irish law significant protection for so-called whistleblowers. That is, people who made protected disclosures. But it's vitally important to be able to differentiate and distinguish between what is a protected disclosure and what is a workplace grievance. So in the legislation, in the Protected Disclosures Act 2014, the definition of a protected disclosure is set out in Section 5, and it also sets out that it protects a disclosure of relevant information, and it sets out then and defines what is relevant information. Essentially, relevant information is information of a relevant wrongdoing, and relevant wrongdoing is basically a breach of the law, some sort of unlawful activity. For example, tax evasion or some fraud or whatever would be clearly breaking the law and would be the subject matter of a protected disclosure. However, grievances in the workplace then are at the other end of the scale, and it can be hard at times to distinguish between what's a protected disclosure and what's a grievance. There was 2 High Court cases there recently in which the High Court was asked to have a look at 2 particular employment law cases. One involved a man called Baranya and Rossadera Irish Meats Group Limited. Rossadera have a place there in Edenderry, not too far from where I am at the moment. But Mr. Baranya was dismissed in September 2015, and he brought a claim for unfair dismissal. He claimed that the work that he was obliged to do caused him pain and suffering and so forth, and he brought his complaints to HR, to the health and safety manager in his company, and to his supervisor. He basically claimed then that these complaints were protected disclosures, not just grievances, but protected disclosures, and as a consequence of that, he was dismissed. He lost his case in the WRC, and he then lost his case in the Labour Court, because the Labour Court agreed with the employer in finding that the issue or issues that were raised were not in fact protected disclosure but were grievances. And this man, Mr. Baranya, went to the High Court to have another look at it, another bite at it, another nibble, and the High Court agreed with the Labour Court and basically said that his issues that he had raised in the workplace were merely grievances, and there was no relevant wrongdoing as understood and required by the Protected Disclosures Act 2014. A second High Court case then involved a Mr. Husford and the Department of Employment Affairs and Social Protection. I've written about this case before on my website, employmentrightsireland.com, but it's worth having a look again. Essentially, Mr. Husford was penalised in the workplace, and he was sanctioned and subject to a disciplinary procedure. He brought a claim to the WRC, and he basically claimed that he was being penalised for having made a protected disclosure. What happened was, apparently, Mr. Husford had sent a series of emails setting out what he claimed were protected disclosures. However, the employer claimed that the disciplinary procedure that arose wasn't for having made the protected disclosures. It was for having sent out all these emails to other people in the organisation, to workplace colleagues and so forth. He ended up again in the Labour Court, and the Labour Court agreed with the WRC that he wasn't penalised for having made a protected disclosure. He then appealed this to the High Court, and the High Court determined that the disciplinary process in the workplace was not concerned with the emails containing purported protected disclosures per se. What it was concerned with was the widespread circulation of said emails and this was what led to the disciplinary procedure against Mr. Husford. So the High Court agreed with the WRC and the Labour Court that Mr. Husford was not penalised for having made a protected disclosure. The key significant thing about these two cases, and indeed any protected disclosure case, is that the penalty or sanction for the protected disclosure legislation is very draconian, very serious. For example, if you are unfairly dismissed in the normal course of events, the Unfair Dismissals Act 1977 will make provision for a maximum compensation award of 2 years' salary. However, the Protected Disclosures Act 2014 can see you being awarded up to 5 years' salary for having been dismissed for having made a protected disclosure. So 5 years' salary in anybody's money is not small potatoes. Likewise, if you're penalised in the workplace for having made a protected disclosure, the penalties for that are significant. They are costly for the employer. So a lot of times it can be very beneficial for the employee if, rather than just being stuck with an ordinary unfair dismissal case, he can actually, or she can, bring a claim for under the Protected Disclosures Act, because the penalties, the sanctions, the remedies are far more draconian than under the ordinary legislation. And that's why it is important to distinguish between a protected disclosure and an ordinary grievance. But in these two High Court cases, Hosford and Borania and Rossendara Irish Meats Group, both cases were not cases where the penalty or the disciplinary procedure or the unfair dismissal or whatever arose for having made a protected disclosure. No, they were more grievances. That was what the High Court decided. Hope you find this video useful. If you do, you might give it the old thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you do, I would appreciate it. Just hit the button down below there, the subscribe button, and hit the bell, and you'll be notified every time I make a new video. And I've been producing new videos twice a week for the last good while. Thanks a lot.